हेलो एवरीवन, स्वागत करुच्ची आपणकर यूट्यूब चैनल पीके स्टडी आईक्यू को। चलते आम आरंभ करवा आमर एक न्यू डिक्टेशन रे लीगल पैसेज 80 वर्ड पर मिनिट रहिबो एंड 800 वर्ड भितर रहिबो। चलतु स्टार्ट करवा। रेडी स्टार्ट। इट वाज आर्ग्यूड दैट द पर्पस बिहाइंड ग्रांट ऑफ parole was altogether different and therefore the nature of offence would be an irrelevant consideration. Stop. Para. Learned counsel appearing for the respondents refuted the aforesaid arguments with the submission that the case of the appellant was duly considered and rejected after finding that it was not recommended by the district magistrate and superintendent of police of Dausa, Social Justice Department of the State of Rajasthan and the superintendent of jail, Jaipur. Stop. It was argued that all the aforesaid authorities had given adverse reports about the appellant. Stop. Next para. We have given our serious consideration to the respective submissions made by counsel for the parties on either side. Stop. Para. We may state at the outset that the reason because of which the High Court dismissed the writ petition filed by the appellant herein is not an opposite one and does not meet the test of law. Stop. The petition is dismissed only on the ground that the appellant is convicted in a case of serious and heinous crime and therefore parole cannot be claimed as a matter of right. Stop. As per the discussion that would follow hereinafter, the conviction in a serious and heinous crime cannot be the reason for denying the parole per se. Stop. Another observation made by the High Court is that since this court had decided the appeal of the appellant affirming the conviction, it would not be appropriate for the High Court to exercise its discretion in favor of the appellant, and if he so desires, he may approach this court for the said purpose. Stop. This again amounts to abdication of the power vested in the High Courts in so far as conviction for the offence for which he has charged, under the provisions of TADA, is concerned. No doubt that has been upheld till this court. Stop. However, the issue before the High Court was entirely different. Stop. It was issue before the High Court was entirely different. It was as to whether the appellant is entitled to the grant of parole for 20 days, which he was claiming stopped merely because the matter of conviction of the appellant had come up to this court would not mean that the appellant has to be. This court would not mean that the appellant relegated to this court every time, even when he is seeking the reliefs unconnected with the main conviction stop. It is more the term of imprisonment is not included in the computation of the term of parole, whereas it is vice versa in furlough stop. Parole can be granted number of times, whereas there is limitation in the case of furlough stop. Since furlough is not granted for any particular reason, it can be defined in the interest of the society. From the aforesaid discussion, it follows that amongst the various grounds on which parole can be granted, the most important ground, which stands out, is that a prisoner should be allowed to maintain family and social ties. For this purpose, he has to come out for some time so that he is able to maintain his family and social contact. This reason finds justification in one of the objectives behind sentence and punishment, namely, reformation of the convict. The theory of criminology, which is largely accepted, underlines that the main objectives which a state intends to achieve by punishing the culprit are deterrence, prevention, retribution, and reformation. When we recognize reformation as one of the objectives, it provides justification for letting off even the life convicts for short periods, on parole, in order to afford opportunities to such convicts not only to solve their personal and family problems but also to maintain their links with the society. Another objective which this theory underlines is that even such convicts have right to breathe fresh air, albeit for periods. These gestures on the part of the state, along with other measures, go a long way for redemption and rehabilitation of such prisoners. They are ultimately aimed for the good of the society and comma therefore comma are in public interest. Stop the provisions of parole and furlough comma thus comma provide for a humanistic approach towards those lodged in jails. Stop main purpose of such provisions is to afford to them an opportunity to solve their personal and family problems. Stop.